G'day everyone, my name's Angela Jackson, and I've just been asked to come today and talk to you about international humanitarian law. And I guess my background is that I'm essentially a nurse, but I've also done a law degree. So international humanitarian law is generally not covered in any law degree, but I've been involved with responding to disasters, and it's very much part of that core curriculum. So I'd just like to start off by thanking my good friend Florian Rasenberger, who's a human rights lawyer, and he actually taught me what I know about international humanitarian law. So basically I'm just going to give you a broad basic idea of what it is, what's the difference between it. So this is what I want you to know at the end of this session. So you will know what is international humanitarian law, what's the difference between Geneva Law and the Hague Law, what's the basic principles of international humanitarian law, what is the difference between international humanitarian law and human rights law, and I'm just going to introduce you at the end to something that's been on the horizon for the last couple of years called international disaster response law. So I guess the first question is, what do you think is international humanitarian law? Does it happen only at times of war? Does it happen in peacetime? Does it make war illegal? Is it the protection of human rights? Does it regulate conduct? Does it protect civilians? Does it protect combatants or people who fight? I suppose before I had done this subject, I never really gave it too much thought, and probably like many of you, I'd heard about it, but I didn't really have it sorted in my own head. So let's go through and we'll try and tease out and give you what international humanitarian law is in fact. So it's a law that is set on international rules. It's the law of armed conflict. It's the law of armed conflict, both national and international, and we will go through those in a little bit more detail. It's a law that limits the means and methods of warfare, so basically says how you can fight and how you can't fight. It protects the people that don't participate in the fighting. It protects objects for survival, such as ambulances, hospitals, water, electricity, and it's really developed from a treaty or custom. And the first treaty or custom was the Battle of Solferino. So Henry Dunant and his good friend Francis Liber came across the Battle of Solferino, which was a battle, and they basically saw that there was a lot of injured people on the battlefield who were not being cared for. So really soldiers on the battlefield. It happened in 1859, and he was rather appalled. That's a picture of Henry Dunant. So what happened was, after that, he witnessed that battle in Solferino in 1859. He returned to Geneva, and that's where the Convention for the Amelioration of the Condition of the Wounded in Armies in the Field were set up. So this was really the beginning of the Geneva Conventions. So the two main sources of international humanitarian law are the Geneva Convention, which is a body of rules which is aimed at protecting victims of war, and then there's the Hague Law, which is the soldiers' war, who basically says what you can attack, how you should attack them, and the use of weapons and military tactics. So the Geneva Law really protected people who were either participating in war, so soldiers, prisoners of war, and also people who were affected by war, so civilians and medical people. And really the whole idea was to limit any unnecessary suffering. So the Geneva Law really was the protection of people that weren't taking part anymore in the fighting. And this is based on the four main Geneva Conventions. So, and there are 3 additional protocols. So we've got the wounded and sick on the land, that came first. Protection of the wounded and the sick at sea. Geneva Convention 3 was the protection of prisoners of war, and 4 protected civilians and those in occupied territories. And then you have the additional protocols, which additional protocol 1 basically broadens the protections of civilians that are taking part in international armed conflict. Additional protocol 2 were the protection of civilians in non-international armed conflict, and the additional protocol 3 really was what established the red crystal emblem and the protections that offers. So basically they require that militants or people taking part in war have to distinguish between those that are combatants, so other soldiers, and those that are not, and to avoid harm for those that are not, and that's really civilians. Article 59 of the 4th Geneva Convention also requires that conflicting parties permit free passage of aid and guarantees that protection, which is interesting if you think about what's going on in the Syrian crisis at the moment. And certainly there's obviously a number of elements involved, but just think about how that's affecting the free passage of aid. And again, ask yourself whether or not that's actually, whether international humanitarian law is actually working in those areas. And then we've got Common Article 3, which again is refers to non-international armed conflicts, which are very tricky in their own right, and we'll tease out them a bit later. So basically that's certain obligations, and refers to looking after civilians and allowing the passage of aid. So the main 4 Geneva Conventions and the protocols really have been developed since 1864 up until 1949. There has been various stages along the way, and that's just really depicting that. We can see that the face of conflict and war around the world is actually changing in the last few years. So you can see in 1919, obviously it was more military personnel that were affected by war and conflict, and have a look at now 2005. And in fact, victims of armed conflict since 1945, 80% of the victims of armed conflict have been as a result of internal armed conflicts. So things going on within state borders. And like the previous chart just showed, more and more civilians are infected by that. And certainly the crisis that's going on in Syria and Iraq and many parts of Africa, Sudan, are affecting large populations of civilians, and also are happening within state borders. So that brings us to the types of conflicts. So we have the 3 main types. So we've got international armed conflict, we've got non-international armed conflict, and we've also got internationalized armed conflict. So obviously international armed conflict was really the traditional and oldest type, so the previous 2 world wars. Non-international armed conflict would be things like a civil war. And things that are internationalized is really an example of that would be the American Independence War when France intervened. I guess more recently you've had Iraq and the coalition forces intervening. So the one that causes probably major problems is the non-international. And I guess the question is, does international humanitarian law apply in these situations? So why do we actually need to distinguish between them? And obviously it's because we need to know whether international humanitarian law applies or whether it doesn't. So it's not applied at all when you've got situations of internal tensions. So for instance, you'd be thinking of a riot or a political disturbance, and again that respects state sovereignty. So the state has obviously got the responsibility to protect in those situations. International humanitarian law is applied to some extent in non-international armed conflict. So like I said, the additional protocols, basically Common Article 3 says that you should still allow humanitarian aid, free passage for humanitarian aid. So in situations where governments have an armed conflict that goes on and they don't allow the free passage of aid, then international humanitarian law would apply in those situations. And obviously it's fully applied where you've got international armed conflict. And that's probably the easiest of the three situations to clearly see that international humanitarian law is applicable, because you've generally got clear rules of engagement, you've got clear parties to the conflict, and assuming that you've got professional military organisations, then they are all subjected to the rules of international humanitarian law. And not surprisingly, these are the treaties that are most well established, and the most numbers that have actually been ratified. So under international obligations, there's about 500 articles, and they're widely ratified. Basically, the Geneva Conventions are universally ratified, but not necessarily all their additional protocols. But where you get a problem is when you've got issues of state sovereignty, so non-international armed conflict. There's 29 articles, and they're not that well developed and not widely ratified. So we'll just have another look at Common Article 3. So Common Article 3, which applies in many instances in non-international armed conflict, basically says that people who don't take any active part in hostilities shall in all circumstances be treated humanely, without any adverse distinction which is founded on race, colour, religion, faith, sex, birth or wealth, or any other similar criteria. So that is really the catch that determines whether or not international humanitarian law applies in non-international armed conflict. So it basically prohibits things such as those that are listed there. So violence to life and person, in particular murder and mutilation, looks at really the gravest of crimes. The taking of hostages, they have to be treated in a particular manner. Basically any humiliating or degrading treatment. So and so things like torture, rape, etc. And obviously it allows the passing of prevents the passing of sentences where people haven't been allowed to have due process, such as a court and jury. And it basically goes on to say that the wounded and the sick need to be collected and cared for, and any impartial humanitarian bodies such as the International Red Cross or Committee of the Red Cross may offer its services to these parties in conflict. So for instance, the mandate of the International Committee of the Red Cross is such that they are supposed to be allowed access to prisoners. They're supposed to be able to provide things like communications, with family members, make sure that prisoners are cared for in a particular manner, so they're fed, they're watered, they're properly housed in a proper accommodation. And really, this is really what Common Article 3 is trying to get around. So it's really just the treatment manner in which prisoners and such are treated. So again, this is where in non-international armed conflict is where often international humanitarian law can apply and is applied. Again, that assumes that the party where we're trying to actually apply the international humanitarian law are signatories to the additional protocols. And there's a lot of very well-known countries that aren't. The United States of America, for example. And you can probably guess why, when you look at things like Guantanamo Bay, why they may not be particularly a signature to some of the additional protocols of the Geneva Convention. And really they're just saying that we are reserving the right to respect our own sovereignty and treat our prisoners of war in a manner that we determine is the best way to treat them. But I'm not saying that's right or wrong, but it's certainly something that you should think about. And then we come to what we call the Hague Law, and this is really the other part of international humanitarian law. And this is where the methods and means of warfare are actually set down. So this really looks at basic principles that have to be followed when a country or a professional army goes to war, and really says how they can actually conduct that war. And again, it's a law that's there, but whether or not it's followed and whether or not it's enforced is a different matter. And again, you can probably think of a few examples. Obviously, the Israeli-Palestinian conflict is one example. Do you think that the way that that's carried out by Israel to the Palestinians and vice versa is that in the true spirit of Hague Law? And we'll just go through and look a little bit about what we actually mean by Hague Law. So again, it's really the basic principles of the law of armed conflict. And the first principle is there has to be distinction. So there is an obligation on those taking part in armed conflict to distinguish between what is a military target and what is not. And you can clearly see from this picture that that was a hospital. And under international humanitarian law and the Hague Law in particular, you're not allowed to bomb or target places that are necessary or that's going to cause unnecessary human suffering, such as hospitals. The second principle would be the one of proportionality. So this really says that you can only use the force that you use must be in proportion to what was used against you. So for instance, if we look at a situation where, I don't know, one soldier has been killed and the other side then decide that they are going to wipe out a major city, then you ask yourself, is this in proportion to what you suffered previously? And so that's really the principle of proportionality. So it has to be in proportion to what actually occurred to you. The next one is targets need to be a military necessity. So for instance, yes, it's probably okay to bomb a tank or blow up a tank, but is it okay to take out, for instance, the whole town's water supply? Is that a military necessity? Now, you could argue perhaps it was, but I suggest that that would cause unnecessary suffering for a large proportion of civilians, and so therefore that would be something that would be not allowed under the Hague Law. Another example would be military necessity might be you would be allowed to blow up certain bridges because that's a path that the military take to move around. So that might work, and you might get away with that. So really it just says that you can't use any more force than is necessary to accomplish your mission. That's military necessity. And then there's laws basically that prohibit certain weapons. There's no a treaty for cluster bombs. So cluster bombs are basically a group of countries have got together and said, okay, well, cluster bombs are unfair, they shouldn't be used, let's ban them. So there's the Ottawa Treaty that banned cluster bombs. So there's certainly, basically, it says that parties need to stay fair, and they need to, there's certain things that are prohibited for use under the methods of warfare. And like I said, cluster bombs is a classic example. And the last principle is basically if there are hostages or prisoners of war taken, then they must be treated humanely. And again, there is, as we all know, if you've got a professional army, there's manners and ways in which they need to treat the prisoners of war or hostages that they take. And you could probably ask yourself again, what happens when that's not the case? And there certainly were a lot of examples of when prisoners of war weren't treated humanely, and the Second World War is probably a classic example. There was a lot of very inhumane treatment of prisoners of war, particularly by the Japanese, obviously the Germans, and no doubt on the coalition forces side as well. Many would argue that Guantanamo Bay is not humane treatment of prisoners of war, and perhaps it's not. And I guess that's just worth thinking about. And the other question then would be how, if people are, or if states, if countries are in violation of the Hague Law or international humanitarian law, what happens next? And we'll just talk about that briefly, shortly. So that really was basically the four main principles. So the principle of distinction, proportionality. So you're only allowed to use a similar force. Military necessity, so it has to be necessary, and obviously there's certain limitations to what you can do, so certain weapons, etc., that you can and can't use. And this is really just a picture of Hiroshima, and John Bolton was a UN representative, an American representative to the UN, and this is what he had to say about the Hague Law. Basically, he just said that it would seem that the United States would have been guilty of a war crime under these laws because of dropping the bomb on Hiroshima and Nagasaki. And I would think, yes, was it basically was that in proportion to what was going on? And we could have an argument all day about that. But again, just an example to get you to think about how this actually works in practice. So the four key sentences, if you would like, is the basic principles of Hague Law, you have to use force that's exclusively against military targets, the principle of distinction. You've got to spare people and objects, particularly things like hospitals, ambulances. This is an example of an ambulance in the occupied territories. Now, there's a lot of bullet holes. There's obviously a huge mortar that's gone through that. Do you think this is acceptable under under the Hague Law? The third one, you must not use any more force than is necessary for accomplishing your military mission. So that's the principles of necessity and proportionality. And then finally, you must stay fair. So no use of prohibited means of warfare, such as cluster bombs. And this is the principle of limitation. So again, that's the four main principles of Hague Law. And really, the whole idea is that people are treated humanely. Hopefully I'm not going too fast. So now what we're going to do is we're just going to have a look, and we'll talk a little bit about what actually happens when humanitarian law is actually violated. So what do we do? Who sorts out the violating parties? Where do we go? Who complains? And how is this relevant to us in Australia? So in 2002, the International Criminal Court was set up and entered into force. It was the first permanent body that had jurisdiction over serious international crimes. And these were crimes such as war crimes, crimes against humanity, gross violations of humanitarian principles, and ones that come to mind were the Rwanda genocide, the crisis in Yugoslavia, what else? Cambodia and the Pol Pot regime would be perfect examples of what would now be would give the International Criminal Court jurisdiction to hold those states to task. But the first principle is that the court will only operate in times of when states are genuinely either not able to prosecute or are not willing to do so, to take people to task who are committing gross violations against humans within their own jurisdictions. So, for example, there was a special court set up to deal with the issues that arose from the Rwandan crisis. Now, that didn't come under the International Criminal Court because that occurred prior to 2002. So there's no jurisdiction for them to prosecute, for the International Criminal Court to prosecute, because it only came into force in 2002. However, where states have actually asked for help to bring people to account for those violations, then the International Criminal Court have been able to set up special courts to give those countries assistance. And that's happened with Rwanda. It's happened with Cambodia, really trying to hold people to account about the Khmer Rouge regime. It's happened with the former Yugoslavia. It's going on at the moment with the former Yugoslavia and the things that occurred there. And really it's just there to assist. So it offers legal and counsel assistance to help these states to actually manage the prosecutions. But the underlying principle and the underlying message of the International Criminal Court is that you must remember that the primary responsibility for prosecution lies first with the states. So I think the main, I guess if you like, limitation of the International Criminal Court is it probably doesn't have a great mechanism for applying enforcement. So even though there's no statute of limitations and it's reserved for prosecution for the gravest of crimes, it's difficult to enforce the judgments, because there's many countries that will allow free passage of these people that are responsible for criminal acts, and the International Criminal Court has no jurisdiction to get these people where that country is not a signatory to the treaty. So, for instance, if Joseph Kony, obviously the International Criminal Court have issued a warrant for Joseph Kony, who's basically responsible for a lot of criminal acts under the Lord's Resistance Army. So it grew up in, I think, Sierra Leone or Uganda initially, and they've been responsible for chopping off people's arms, taking child soldiers, etc. But unless Joseph Kony actually moves into an area where that state is willing to hand him over, there's probably very little that the International Criminal Court can do in the meantime. Probably one of the only benefits is that there is no statute of limitations with International Criminal Court warrants, so that warrant will stay viable forever. So even if he happens to head off to London or somewhere that's a signatory to the International Criminal Court, he could still be picked up in 20 years' time and held to account for the crimes that he's committed. And I guess we need to then think, well, how is this all relevant to Australia? Well, it's probably relevant to Australia because of their involvement in various campaigns along the way. Just before I talk about that, this just really shows you who the main signatories to the Rome Statute or the International Criminal Court. And again, you can see that there's a lot of people missing, so there's a lot of areas where there's a lot of places where I guess people who commit gross violations against humans can be harboured. And again, I think I just go on to the relevance to Australia. So Australia has been involved in a range of armed conflicts, and we have seen recently, obviously, we've just now going back into Iraq. We've been involved in Iraq in the past, Afghanistan, and Iraq several times actually. And so really, basically, not only members of defence forces who are employed in these places need to know about international humanitarian law, but also other organisations such as AusAid, or DFAT as it is now, and other members of the humanitarian sector, such as the AusMet, the Australian Medical Assistance Teams, non-government organisations, who are going into places like Syria and Africa and either doing peacekeeping or humanitarian missions. So really there's things that you need to know, and things that in a certain way that these people need to behave. Obviously the Defence Force, I think, would be well up in acts and methods of warfare, but perhaps not necessarily on international humanitarian law and the rights of the obligations on states to allow things like passage of humanitarian aid and to protect people and places that are not military targets. So just summing up now, international humanitarian law, hopefully we all know now that it's the law of armed conflict, and its really aim is to limit the effects of armed conflict, to really limit the effects on civilians in particular. It does not apply during peacetime, so it only applies in times of conflict, armed conflict, and it sets minimum standards that cannot be taken away. It does not regulate whether a state may use force, so it doesn't it's silent on when people can and can't start a war. The Geneva Law and the Hague Law, so the Geneva Law protects people taking part in combat as well as civilians. The Hague Law basically is the law of how to conduct a war. And Common Article 3 really applies to all armed conflicts. So basically, Common Article 3 basically says that you need to be treated humanely, and you can't distinguish on things like sex and religion, and prohibits certain violence, taking hostages, personal dignities, basically protects humility, and says that anyone who is captured needs to be given a fair trial, and they need to allow free assistance. So an organisation like the Committee of Red Cross has the mandate to be able to access those people. Okay, so now I just want to touch on, we've looked at international humanitarian law. We know that really it protects, international humanitarian law is protective. It's really to stop any unnecessary inhumane treatments. And Hague Law is obviously the law of how fighting should be conducted. And so then we move on to, well, what's the difference between this and human rights law? So what do you think the difference is between this and human rights law? Just have a minute to think about, if humanitarian law is protective, why then is human rights law any different? And basically, I guess the main difference is that human rights law gives you an inherent entitlement, and it's an entitlement which every person, just because they're a human being, are entitled to. Doesn't mean that all humans are entitled to the same human rights, and it's very much dependent on what country you live in, and what body of law that they see as being important. So human rights law then is it's a set of rules, international, and there's various signatories to various statutes. It's individual to each state, so it is something which the state or the country that you live in gives you. It's been established by treaty or customs. It can, in certain circumstances, be taken away. For example, if you commit a crime, your right to freedom of movement can be taken away, and you can be put into prison. And the one big distinction between that and international humanitarian law and Hague Law is that human rights law applies in times of both peace and war. So whereas the other two only apply in times of armed conflict, human rights law is there all the time. So whilst they both strive to protect lives and dignity, human rights law is there, like I said, all the time. So the difference between them, I think I've probably just alluded to that. So humanitarian law, law of conflict, it can't be taken away, so it binds state actors and non-state actors and other individuals, such as security companies who are operating in an area of conflict. That's what we mean by other individuals. It's both horizontal and vertical, so it goes up and down and across. And it conducts basically how hostilities should be managed, how do we manage prisoner of war, and like I say, it's where the Red Cross gets its mandate, and that's where the Red Cross has a big part to play. The committee, there's two different parts to the Red Cross. There's the International Committee of Red Cross, and their mandate is drawn from times of war, and that's where they operate at times of war or armed conflict. Whereas the Federation of Red Cross work in times of peace to provide humanitarian assistance. So I keep going on about the Red Cross, but you just do need to distinguish that the Committee of Red Cross mandate comes from times of war and armed conflict. So just moving on, the difference then to human rights law is human rights law is operational both in times of peace and war. In certain circumstances they can be taken away. So for instance, if you commit a crime, or in states of emergency, governments can decide that people aren't allowed out on the streets after 6 o'clock at night. It basically comes from the states, and the state determines what human rights law will apply through legislation and signatories to various treaties. And it's generally vertical, so it comes from legislators and the state down, unlike international humanitarian law, which is also horizontal. So they both have some commonalities. So both of them aim to protect human life. They're both supposed to prohibit torture. So even if you have committed gross violations, it's not okay for people to be tortured, although in some countries maybe it is. It prescribes basic fair trial rights, so people are entitled to certain representation, so that may well be that they're entitled to legal counsel. They are entitled to judge and jury depending on what the state decides. It prohibits discrimination, and it in certain circumstances provides for the protection of women and children, and there's a lot of treaties where there's rights to the child and such, that's where those protections come from. So the international rights of the child, I think, things like that. And also it regulates aspects of the right to food, health, education, and again that's very much dependent on the state and what the state can afford. Now I just really wanted to touch on something that's just been on the horizon since about 2011, and is certainly being developed at the moment. And there is particularly with medical teams, there's a lot of work going on at the moment to set minimum standards, etc. So what happened was at a conference there was a number of bodies led by the Federation of the Red Cross. So there was a number of both countries, state actors, large non-government organisations who have come together and basically agreed that there needs to be some legally binding rules and regulations set up for people responding to disasters around the world. And it really happened because of things like Haiti and the large number of people who responded, and the fact that coordination and collaboration and who was doing what was very poorly regulated. And I guess they've realised that at some point people may need to be held responsible for what they're doing and how they're carrying it out. So there was a international conference of the Red Cross and the Red Crescent societies that decided to progress this set of guidelines, basically, which they are calling International Disaster Response Law. So it's really guidelines for domestic countries to encourage them to set up certain regulations so that in times of disaster recovery efforts, there's guidelines which say how both the country should behave and how those that are responding to disasters should behave. And it was, like I said, it started in 2007, and the first draft came out, or the first draft of guidelines were released in 2011. And basically the reason that it happened is that particularly weak countries had very few laws in place that would guide how people responded to disasters. And having said that, even though a lot of poor countries struggle with this, there's a lot of first world countries as well that haven't thought about how do they manage people coming in to respond to disasters. Now obviously first world countries have a lot more money and resources, but if you look at things like Hurricane Katrina, and you look at the earthquake in Christchurch, they were examples of how even in a sophisticated system there was still problems, particularly in Hurricane Katrina, where state and federal borders were an issue. How do people basically move through those two levels of authority? So these guidelines are really a way of addressing that sort of thing. So really looking at how are things regulated, what slows up distribution of relief. So how do we set up rules to say that in certain circumstances we could waive, say, for instance, the need for, I don't know, to have a certain piece of paper or regulation to take a certain, say for instance, medication into a country that's vitally needed at times of disaster. So you might think of something like medications for malaria, and perhaps some countries have drug protocols that say, well, you know, it has to be this, this and this, or you have to get this, this and this authority before you can import those drugs into a country. So really looking at those technical issues and really sort of trying to address things like over-regulation and bottlenecks and under-regulation. So again, that's things like uncoordinated efforts. So who says who can come in, and are they operating under minimum standards? And for instance, an example of that is medical teams going in. So what sort of standards are they operating under? Are they registered? Are they working alongside one of the local health authorities? And there's a lot of work being done in that area. Things like the urban search and rescue teams have already become quite well advanced in that. And the result of that is that a lot of times when disasters happen, there's particular teams that are actually invited by host governments to respond because they've already been accredited. The government knows what sort of standards they operate under, and so on and so forth. So really, they're aimed at promoting uniform legislation, and it's really to try and eliminate some of the hurdles that happen at times of disaster. Looking at things like minimum quality of standards, so that affected governments should insist upon a particular standard, and for a health team it might be that they're accredited by the World Health Organization as having met a particular set of standards for a disaster response team, for instance. And really they're looking at government's legal facilities, so looking at things like visa and entry requirements and the domestic legal status, so that people responding have a legal right to contract with parties within countries. And again, the core idea is really that the domestic actors, so the affected countries, would have the primary lead and the primary role, and the idea is that they would have these systems in place before, as part of their disaster response activities, so as part of their planning really, to get them to think about some of these things. And there's obviously responsibilities for international relief providers. So again, if you're taking a medical team in, you need to ask yourself, who am I working with? Am I going to be tasked by the affected country? Have I been asked to respond? And where am I going to work when I get there? And that should be a role that is directed by the affected country. And then again, looking at, like I just said, the legal facilities. So how can I conduct my work when I get to the affected country? So do I have legal rights, such as the right to contract, and so on and so forth. So there's going to be some things that would be conditional. So for instance, if I'm going to be going in, I keep talking about medical teams because that's what I'm most familiar with, but for instance, if I'm going to go in with a medical team, then I will agree that the minimum standard I might do will be I'll deliver aid in a similar fashion that I deliver healthcare in Australia. There's obviously a core set of minimum standards for healthcare, which is in the Sphere Handbook Guide, and it might be that my organisation makes a pledge, or as part of their licensing arrangements have shown that they will meet Sphere standards, which are minimum standards. So it's all really aimed at preventing some of the circuses that go on at the moment when disasters happen, and giving control to the country that is most affected. And part of that is to get them to start planning laws and how they will manage this before the disasters happen. And I think it's a fantastic initiative, and it will no doubt help countries to get their head around how to actually manage this before they're in a situation where they're just making it up on the run. So I think I'm just about done. So I just want to sum up by just saying that hopefully you now understand that international humanitarian law is the law of war, only applies during times of war and armed conflict, and it has two main bodies, so the Geneva Conventions and its additional protocols, which protect victims of war, and the Hague Law, which obviously protects how war can be conducted, so how armies need to fight. Human rights law, on the other hand, applies in both peacetime and war, and it's normally decided by the state. So it's a vertical law that is given from the state to its constituents. And I've just touched on international disaster response law, and that will really is in its infancy and is still being developed, but that's really going to determine how and who can respond to disaster situations. And obviously that is coming, and like I say, there's a lot of work happening at the moment to set up minimum standards and so on and so forth. So I've just put a few useful links at the end there that you can find some more. The Federation of the Red Cross in particular has got quite a bit of stuff on the new International Disaster Response Law. So hopefully you've found it interesting. I've just really given you a broad brush of international humanitarian law and the law of armed conflict, and really just tried to give you a general idea about how all that different legal framework applies, and particularly how it applies to healthcare providers. So hopefully you enjoyed that. Thanks very much for your time.